new partner in the company, can there be a provision that says, okay, you can become a member, but you're not going to vote on anything?
So when ownership, and there are good reasons for estate planning purposes to have that ownership in spouses' names, especially here in Florida. So the default, if ownership is owned by spouses and one spouse passes away, then the default is that that full interest, however much it is, goes to the surviving spouse. However, in an agreement, we can specify, we can require a forced buyout at a certain value. We can set up membership to say, hey, these are, say, voting interests and these are non-voting interests. So we can do these things, but that's if you've done an agreement.
In terms of limiting the voting interest for a surviving spouse. Mm-hmm. So for example, if the spouse becomes the new member or the new partner in the company, can there be a provision that says, okay, you can become a member, but you're not going to vote on anything. You're a non-voting member. You'll get distributions whenever we decide to have distributions.
Correct. And so what will happen there is you want to set up the company in the first place as, and let's talk about an LLC as an example. You want to set that company up as a manager-managed LLC rather than what many people do is like, oh, just set it up member-managed. Manager-managed, the managers run the company and will have more control. When you have member-managed, that won't work. So there are things that need to be done in that agreement to link it all together.